Hello, 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 and happy holidays to everyone. Welcome to the second session of four on intellectual property protections. This series is being sponsored in is in collaboration with the U.S. Patent and Trademark Office, and it is a session series that I developed to be able to support other small business owners in building the business of their dreams through intellectual property protections. We talked in the very first session about what is intellectual property, what is intellectual property protection, what are the three primary types, and then we also talked about trade secrets. We had an amazing panel full of attorneys and a representative from the USPTO. And so we're going to continue that same magic today. Of course, I know that everyone is winding down for the year. So thank you so much for being willing to join us. I hope that you find it useful, and these webinars will be archived as well on LinkedIn and YouTube at the Fast Forward Podcast channel on YouTube if you want to refer back to it for answers and support. We have a chat available for on both LinkedIn and YouTube, and then also there is a chat in Riverside. So if you have questions, please feel free to drop your questions there. I'm Kaylin Romaine, founder and CEO of the Forward Collective Group. I'm also an intellectual property holder myself. So I have successfully filed for several trademarks to protect my ideas over the years. And then I'm also an organizational psychologist and executive coach. More than anything, I'm a founder just like you all and a creator just like you. So I understand how important it is to protect what you're creating and all of your brilliant ideas, which again was the catalyst for this series. I have several guests with me today, and I'm excited for you to get a chance to get to know them. I'm going to go in order of the lovely faces that I'm seeing. And so I'm going to start with Tomeka, who is at my top. Tamika, can you please introduce yourself to the listeners and let them know who you are and how you help?
Thank you, Kaylin. My name is Tomeka Oubichon, and I'm the Regional Outreach Officer at the Northeast Regional Outreach Office, headquartered in Alexandria, Virginia, at the United States Patent and Trademark Office. I serve many of our stakeholders, such as yourselves, in sharing the love of intellectual property, education, invention education, and how to protect your respective intellectual property. And that's what I do, and that's what I'm here for today. Thank you, Kaylin.
Awesome. Thank you so much. Next, I see Joanna. Joanna, please tell us who you are and how you help.
Hi, good morning and good afternoon, everyone. My name is Joanna Luna. I am an attorney with Omnis Law. I work with the intellectual property and the AI, cybersecurity, and tech transactions practice groups. And so I help to protect ideas and to help my clients' projects come to life. And trademarks is the fun side of what I do. And so I'm really happy to be here and to share my brain today.
Awesome. Thank you so much. And last but not least, Stephen, please tell us more about you and how you help.
Hi there. Good morning, good afternoon, good evening to everyone. My name is Steve Shape. I am chair and partner at Omnis Law of the IP Group. So my practice has been quite substantial over the years in areas of patent, trademark, copyright protection. I have worked with many inventors, small business entities in achieving their intellectual property. And I'm happy to be here today to try to answer some questions and provide additional information to assist others in being able to get their intellectual property and work with the USPTO.
Awesome. Thank you so much. I love how you all introduced yourself because I heard three key words. Words always stand out to me, y'all. And I heard all of us speak about founders, creators, inventors. It's so interesting because growing up, so part of my background, I grew up lower middle class, from a working class background and family. And so the idea of being an inventor, a creator, a founder, that just was not language that we used in my household growing up. And so to grow up and realize that the ideas that I have are worthy of being protected because I am creating things. So I'm a creator. I did start my own company. I'm an entrepreneur. So I'm a founder. And guess what? I'm inventing amazing things. I'm an inventor. those three words to be used as descriptors for me alone is like still shocking. And so the first thing that I want to introduce to you all is the idea that yes, those three words, inventor, founder, creator, they apply to you. It is not just some magical wizard who's sitting over in a corner who gets to be called an inventor. It's not just Thomas Edison. It is not just who is it? Mark Zuckerberg, right? All of us have the capacity to be an inventor, a founder, and a creator. And if you have the capacity to be an inventor, a founder, and a creator, then you have the capacity to protect what it is that you are inventing, creating, and founding. And so today, I want to spend some time sharing what I have learned so much about through the USPTO's website. I purposely wanted to go through the website instead of just creating a presentation about it because I really wanted to show you all how accessible this is. So if you can get to the internet, you can get to uspto.gov and start exploring. I'm going to point out just a few key pages that I think are particularly relevant. And then I'm going to ask some questions of our esteemed panelists to get you all some important information so that you can walk away with some takeaways and, most important, some action steps to take over the next few weeks as you celebrate the holidays and get ready for the new year. So if you are ready, I am ready, and I'm going to share my screen because I want to share the internet. Okay. Can you all see my screen? Yes, we good? Okay, perfect. I think you can. I'm seeing it on Riverside, so I think you can. So, first and foremost, again, the big thing is it is uspto.gov. So, if you are going to any website and it is .com, some other .edu, .net, that is not the USPTO's website. One quick way to know that you are going to something that is an official government site is that 98.99997 percent of the time it is going to have .gov at the end. And when it says .gov at the end, you know that is the official government website. I bring that up because anyone, and I mentioned this in the first session, that has filed for a trademark, a patent, or a copyright, as soon as you file that, you immediately start getting all of this information and letters and emails from all these people. And it sounds so official, but it's not really them. It's not really the people. So, right, it's not really the USPTO. And so I don't want you to be alarmed if you start, again, finding resources, stuff starts popping up as sponsored ads. It's not that it's bad, it's not that it's wrong, but it is not necessarily the official USPTO's website. And so that's the first thing. The second thing I want to bring up is that there are a ton of resources for you to access here. Now, this particular session is called USPTO Resources and Legal Allies. And so I think that that's an important hybrid to keep in mind because even when you secure an attorney and if you choose to secure legal representation, a lot of us feel more comfortable if we come into that conversation with certain pieces of information in hand. We want to be an informed partner with our legal ally as we're going through the IP protection process. And so the USPTO has provided a wealth of information on the website to help you get started with thinking through some things. So again, even as you're partnering with your legal ally, you can still be informed and ask certain questions to make the partnership and the application process flow smoothly. So with that being said, we're going to start here at the top. So if you'll notice, this top menu is broken down by patents, trademarks. Then they have some information about policies, which I think is particularly important, and then learning and resources. I'm just going to start here, and I'll open it up like it's new tabs because I think that'll just make it easier for this. Actually, no, it didn't let me. Okay. So if we go here, you'll see that it's broken down in 6 key sections. So we have basics, starting to catalyze the application process, asking for assistance, and then maintaining, which is post, right? So after everything has been processed, how do you maintain it, which is extremely important. Helpful resources, and then for independent inventors if you want to file on your own. So if you want to know more about just basics, let's start there. If we click this page, it's going to open up with this really cool graphic at the top that'll tell you, hey, at a baseline, this is what the process will entail. There are 5 steps. Now, obviously, we know it isn't necessarily just one day at a time, right? There are blocks of time in between each step. But I think this overview is helpful because, again, if you're like me and you grew up in environments where you just didn't necessarily know a whole lot about intellectual property, it may not be something that you know offhand. So, again, thinking through the steps, they have a nice menu on the side that gives you that overview, and it's in sequence, so it tells you which ones go first, second, third, etc. And then it breaks down in the steps, each one, and then from there, each of these individual steps has its own bank of resources that you can go to. So again, they've made it really easy to understand the process at a glance, so that even if you opt to partner with a legal ally and secure an attorney to help you through the process, you can still be informed about what the process will entail, and you don't have to go into the process in the dark. I want to click on the glossary real quick because I think that this is extremely important. Because again, if you are like me and a lot of this stuff was totally new to you, some of these terms may sound unfamiliar. And I am not an attorney, though I did grow up dreaming of being one, but I did not realize that dream. So, with that being said, I don't know all the legal terms. The USPTO has made it so easy for you to be able to see and get information, to understand, again, all the steps of the process, the terminology, the sequence, etc. So in this glossary, you can click by letter. So it's just like any other type of dictionary you'll see, you can find words and phrases by letter, or you can honestly just scroll down. So if you really wanted to take it and just go like top to bottom, you could just scroll through the glossary if that is something that you find helpful. And you'll notice for certain terms, if there is a page of helpful resources, they've also included that link as well to help you. So if I wanted to understand what does abandonment mean for a patent, you just read here. But if I wanted to see more, okay, what is MPEP 711? I could click this, it's going to take me to a page that explains even more. And again, I know this is an official USPTO site because it says uspto.gov at the top. So if we go back, again, this is covering just patent basics, and these are called breadcrumbs at the top. I'm sure all of us are familiar, but I just want to introduce you to this part because I know sometimes I hate having to go all the way back to the top and like walk my way through like Hansel and Gretel. So they've set it up to where there are some really nice breadcrumbs at the top, so you don't have to go all the way back to the top. You can just go back one piece of the breadcrumb and then be able to see this section here. So again, the website has been set up so that it is fairly simple to navigate. They have a couple of ways that you can navigate to the information that you need, and they have tons of information to support you, whether you want to file independently or if you want to get legal allyship. So, when you think about the application process, a lot of us are going to end up filing online. And so, if you want to get started with filing online, again, you can be able to click this. It's going to explain all the information to you about how to start that filing process. Tons of graphics too. I know sometimes, especially when we're reading legalese, it can feel like it's like our head is spinning and your eyes start glazing over. So they've done a great job at creating graphic elements too to make it easy for you to see and understand what are the steps, what are the things that you should watch out for, so you can always see these resources. Okay. So I'm going to look over. Let me make sure that there's nothing in the chat. Let's see. Oh, I think we lost Stephen. I didn't realize that. Let's see. Okay, Stephen, are you with us?
I am. I don't know exactly what happened, but I apologize.
No worries at all. Okay, perfect. Sorry, I was sharing the screen and on another page. I didn't realize we lost you. All right. So, gonna go back here. Let's look at trademarks. So, to be honest, for a lot of us, trademarks may end up being our very first step. I know trademarks were my introduction to intellectual property protection simply because I wanted to trademark my business's names, and I wanted to trademark my logos so that people could not use them inappropriately. Now, full disclosure about me, again, I'm an organizational psychologist and executive coach. So, as a service based provider, what I create, whether that's training frameworks, survey products, um, let's see, books that I write, things like that, all of that is what I sell. So, I don't sell widgets or hair clips or cell phones. I sell information. And so for me, it's very easy for people to take that information and pawn it off as their own, especially when you start creating social posts, or different explainer videos. Somebody could easily just copy that and say, hey, I'm Forward Collective Group. Look what I made. And I wanted to protect that so that no one could pretend that they are the Forward Collective Group when they are not. And so the purpose of me trademarking, again, things like my business name, key phrases that I use and concepts that I developed, was so that I could have the exclusive usage and rights to not only the words and phrases and logos themselves, but also the benefits that would come from that. Because when people start to know you for certain things, or they start to recognize your logo, or they start to recognize your business's name, I want that to point back to me, Kaylin Romaine, not Sally Sue or John Doe, in some other place. So again, for a lot of us, trademarks are probably going to be like that first toe dip into the world of intellectual property protection. And so I think this page in particular would be pretty helpful for you all. So just like with patents, right? I want you all to be aware that there are a ton of free resources available. I cannot stress that enough. It is not that you don't want to secure legal allyship, because I strongly encourage everyone to. You are not an attorney unless you are an attorney. But for most of us, we're not attorneys, right? And we don't know all of the legalese and all of that stuff. So I know for me, having an attorney was incredibly helpful, and I probably could not have experienced such a smooth process without one. But I also recognize that for a lot of us, we want to know information in advance, and we want to understand what all of this means. So if you are looking for free resources, please go to the USPTO.gov website to access all of this. Everything I'm pointing you to is 100% free. It costs $0. It is available on the World Wide Web. So if you want to know about just trademark basics, similar to patent basics, here we go. So they have the 4 steps up top, and then you can start to walk through the graphic elements of each of those steps. So application, examination, publication, and registration. Just at a baseline level, those are the 4. One thing, or actually 2 things that I want to point out, and I have this because I was sharing it with somebody else. Again, I share this stuff with people all the time. The first thing I want to share is, what is a trademark? I think this is the one that really gets people because, like I said, a lot of us didn't grow up thinking that the ideas that come from our mind are worthy of being protected. So, understanding what is a trademark, I think, will really drive home the value of having a trademark for yourself. So, what is a trademark explains what is it, owning versus having a registered trademark, use of the symbols. So when you're seeing those TM, SM, and that R with the circle around the symbol, again, most of us are so used to seeing it from big companies, we don't know the difference between them. And so this is going to be extremely important. A quick note about that, right? So you'll see people, they will fake like they have a trademark, and they'll put the R or they'll put the TM. They are just pump faking you, right? They faking you out so you don't see them going up to take the shot. You have to do research to see if that is actually registered. And if it's not, and that's something that you created or something that you are planning to use, you have the potential to file for that trademark. So don't be deterred just because you see the symbol. This is also where legal allyship becomes important. You should still do your research. So again, that's another note, and this page is going to explain for you what all of that means. So I'm going to go back, because the other thing I want to show is this. This is like one of my favorite pages on the whole website. What is the difference between trademark, patent, or copyright? Now, in our first session, Elizabeth was so gracious to explain to us about the importance of layering protections. And then Judy and Xavier, backed it up with giving real examples of their clients, and how they had layered protections. This, I think, is a good explainer so you can understand the silos that each of the protection types fall under. But when you're thinking about layering protections, this is also a really good way to understand how you might sequence that layering, and how you can get comprehensive protections for what it is that you're creating. So, again, this page is explaining the difference between trademarks, patents, and copyrights. And you can scroll down, they give examples of them. And then again, they start to break down the difference between trademark and brand, which I think is super important because everybody swears up and down, oh, pay me $5,000 and I'll teach you how to create a brand. Join my 6-month boot camp for $25,000 and you'll learn how to create and protect a brand. Guess what? Some of that same information that they're going to have you paying and you don't know who they are or whether or not it's valid, you could be able to find more information about that for free on the USPTO's website. So, the last thing that I want to show you here is, do I need an attorney? Right. And so, this is important because I think some of the questions that have come up with folks is like, well, why do I need an attorney? I don't really need one. I think, folks are in cahoots and they just trying to get you to say, no, people are not in cahoots. Here's the information direct about, do you need one? The short answer is no, you don't need one. However, it is likely going to be extremely beneficial to have one. And I'm going to pause for a second because I want to explain to you all. Actually, I'll wait. I'll wait till we come off camera because I'm gonna tell my little story when we get to that part. All right. So I'll come back to that about why it's important, and I'll give you examples of my own. Just quick note about me: I believe I have 13 registered trademarks. Again, for everything from phrases to the designs of my logos to my company names, etc. So that was an investment that, just to talk numbers, I think total I probably paid maybe about $25,000 over the course of 2 years for that. And I used an attorney for every single one, but I will tell you, there have been times where people have tried to poach what I've created, tried to present themselves as if they were me and my company. There have been times where folks have tried to manipulate data and information, and it has come in clutch to have that protection. I also have things that I am licensing to folks to be able to use, and that is ongoing revenue for my company. And I am able to do that safely with protection because I went through that process. So, something that cost me, again, low five figures is probably going to net me millions of dollars of revenue over the life of my business, and potentially hopefully create generational wealth for my family because it is something that I own and can have control over the use and representation of. So, again, there are benefits to protecting what you create. All right, last but certainly not least, I want to take you to learning and resources. This is like, how can I put it? This is like the university of the USPTO, right? So, first and foremost, you can find and attend events. So, if you are interested in going to live or virtual events, you can click this page and it's going to tell you more about everything from courses that are coming up, other things, and it's going to tell you where it is, right? And so this is going to be super important because, again, for some of you, you want to learn more. All my folks who are like, I need a live person, I don't want to do this, that's cool. Go to an event. Okay. Another thing that's helpful, and I know Elizabeth mentioned this before, and I'm sure Tamika's going to bring it up as well, the patent and trademark resource centers. So these are centers that are, again, a network of live folks who can be able to support you, and it is through libraries, whether that's academic, public, or state. And so this page is going to help you find a resource center if you want to search. It's also going to talk to you about how they can help. And if for people who are like, you know what, I want to advocate for other people, if you want to become a center, here you go. Here are the links here. And so, again, these resources are all available right here on the USPTO.gov site. The last thing that I think would be really helpful, statistics and data. I know I'm a numbers person, and so being able to just see information about how the USPTO is impacting communities around me, what is happening with patents and trademarks on a database level, whether that's by community, other demographics, all of that is available here. And then they even have some stories to tell you about success stories. But we're going to be talking more about success stories on January the 8th. Shameless plug, in our third webinar in our series. And then last but not least, kids are creators too. So if you want to start teaching the babies and letting them know how to be able to create the inventions that they develop, I know some kid entrepreneurs that are doing their thing. They deserve protection as well. So if you want to start introducing these topics to these babies in your life, you can click on resources for kids. And for the teachers who may be listening in, if you want to add this into, let's say, your civics lessons or your econ lessons, if you have some entrepreneurship classes in your schools or programs, after school programs, there are resources there for you as well. So I am going to stop sharing now. I think I done talked way too long about that website. I think I covered everything I wanted to touch, but I'm going to keep that page pulled up just in case if we want to refer back to it shortly. I want to pause though before we get to the questions for our esteemed panelists and share just my own stories. Again, you don't have to secure legal allyship in order to file for a patent, a trademark, or a copyright. However, it does make the process smooth, but there is a caveat with that. It makes it smooth when one, you are working with someone who is both knowledgeable and someone that you trust. And then it also makes the process smoother when you are willing to commit to being responsive in the process. Now I'll tell you my own little story. So, one of the things that I discovered throughout that process is the importance of being with an attorney, partnering with an attorney who is knowledgeable and that I trust. There are certain nuances to the application process, to the way that you word things, to the way that you select your classes. And actually, I'm going to show about that too, because that's really important. And so, you may, as the person who is filing, as the inventor, the creator, or the founder, you may not know all that language. And so having an attorney who is extremely knowledgeable, who you trust, they'll know how to ask the questions that you don't even know to ask, or ask for the information that you don't know to give, to make sure that your process flows smoothly. So, for example, when I was filing for a trademark for a catering company that I had started, and I was going to have cooking videos. So there is a particular class for non-downloadable content. I can't remember the exact number, but then it's a different class if you're having classes or things that are downloadable, or it's like videos or DVDs that somebody can get. And so I didn't know about the differences. All I was looking at was probably like the first couple words in the class, because again, it's like legalese, your ass start glazing over. And my attorney was like, "Hey, tell me more about how you expect to monetize this content." And I was like, "Well, it'll probably just be a YouTube channel." And she was like, "Right, do you plan to let people download it? Is it going to be something where it's courses that they can download and keep for themselves?" And I was like, "I don't know. I don't think so." Right. And so we were talking through that business process. Now, that helped me in two ways. Number one, it helped me to select the right class, because it costs to be able to file for multiple classes and to be able to delineate between the two. And you want to make sure that you have comprehensive protection. But it also challenged me to think long term about my business, because at that time I was just like, "Oh, I just want a YouTube channel." And it was like, no, but in a year, in 3 years, in 5 years, where do you expect this to go? How do you plan to grow this aspect of this business? Is it going to be something where you're just catering live events? Is the YouTube channel going to be for marketing and you don't want them to download it? Will you sell classes? Can that be passive income or revenue, excuse me, for your company? So again, all of those questions from someone, she's not, a caterer, she is not a chef, she's an attorney, but her understanding of how to draw that information out of me in a way that felt non-threatening, but really challenging me to go beyond just this short term thought process was so helpful. And so, again, that knowledgeable and trustworthy legal allyship is going to be the difference between you paying a lot of money for short term protection that won't evolve with your business. I will say for sure, just in my own experience, that patent and trademark and copyright protection, it is not a short-term solution. It's for the long term. In fact, even when you get them, like, it's not just for 3 months, it's for years. And so if it takes you a little bit longer to secure the right allyship, to read through and become knowledgeable about the process, to think through your business plan, and then move forward with the process, I would rather you do that than hurry to file just to do something. And then you have to go back and look to file again and again and again, because that just complicates the process. The other thing that I'll say is that sometimes you will experience what are called office actions. And so that is when the examiner has questions about certain things. And so there was one case where I had listed a description for a virtual course I was hosting in a way that was designed to market it to the end user, right? So I wanted to have attention grabbing keywords that would make people sign up. But I had also filed for protection under a class based on this being an online educational course. And so the examiner basically was like, hey, I see this language, but this doesn't appear to align with your class that you selected. And so my lawyer was like, hey, update the descriptions for these cores. Like, I know why you put that because it sounds catchy to your end user who you want to sign up for the class. But change this verbiage because it doesn't align with the class. And this is what you should put based on my experience, what I've seen, what I know. I changed it. It ended up going through smooth. After that office action, we were able to respond and submit what's called a specimen, and everything was good. So again, those are things that if I had probably got something that said office action from the USPTO, I'm like scared, nervous. What do I do? Do I need to throw it all out? Do I need to start out? And it was as simple, quite literally, as changing 10 words in a description on my website. And so, again, this is the power of legal allyship because they are the trusted voice of reason in a process that can feel overwhelming because this is new to you. But honestly, a lot of things are much more simple than we think. And having that support makes that process so much smoother. So, those are my two stories. Again, as someone who has secured multiple levels of IP protection and still going. I got some things that I'm going to be filing for 2025. And so I want to make sure that you all know, again, the USPTO has tons of resources for you to get started with learning the process and becoming knowledgeable. But then you also have amazing attorneys, two of which you're going to be hearing from in about 23 seconds, who can give you more information about, again, how to make this process smooth, so that you get the protections that you need for the brilliance that you are sharing with the world. So, with that being said, let me pop over to the chat. Let me see. Do we have any questions? I don't see any here. All right. So, I'm going to start with my questions now. And I have three for the panelists. We're going to do round robin style. And just to kick it off, I'll make sure to say who is first. And then after that, y'all can kind of just take it from there. Okay. So, first, how can legal representation be useful during the IP protection application process? I want to start with Tomeka with that. Of course, you knew I was going to come to the USPTO first. Tomeka, if you can just let us know, how can legal representation be useful? And then I'd like to hear from Stephen and Joanna.
Sure. Thank you, Caitlin. Uh, Definitely, we always say, it's up to you to decide how you want to represent either yourself as a pro se applicant or to pursue legal representation. And if you do decide to use legal representation, it's important to make sure that that representation is vetted. We do have on our website, uspto.gov, that Kaylin beautifully showed you earlier, a list of practitioners that you can actually go through our website and see. And they're either attorneys or patent agents. And so if you feel free to do so, please visit USPTO.gov. It is very important because of per Kaylin's personal stories. There are some things that uh, you may not see, excuse me, that may be pointed out to you through that legal representation that can work to your advantage. And remember that your IP strategy is your business strategy. So it's important to look into all of your options. And that's what I have to share.
So sorry, Stephen, before you hop in, I actually want to share the screen real quick because I want to show where that page is. Thank you so much for saying that, Tomeka. That was one that I should have shared. So here we go, everybody. So this is finding a practitioner. So if you go again, this is with the breadcrumbs under learning and resources, and then patent and trademark practitioners, finding a patent practitioner. And then here you can click this website link, which is on the USPTO's website. And then it's going to take you to where you can conduct a search. So that's just an FYI. And I think, let me see, is there, yep, there's a separate one for finding a trademark practitioner. And again, same process. So they have these different websites that you can be able to find someone here. Okay, perfect. Sorry, I just wanted to make sure that I showed people on
That's
the call how to get to it. Thank you so much. All right,
excellent.
Stephen, let us know.
Hi there. Okay, so as Kaylin indicated, it is very important to have guidance when you're going through the process, right? And that's really an important aspect of why legal representation can be helpful. Planning for growing your business, for growing your brand, for growing your activity out in the marketplace. Also, a very important aspect of why legal representation can be assisted. Um, Managing your risk, as Kaylin also indicated, managing risk is really important. You could be doing things out there in the marketplace that you're even not aware of that could come back potentially to cause concern. So you want to have somebody on your side, a trusted advisor that can help. And then certainly preparing the applications, prosecuting the applications, and continuing to grow the brand and grow the patent process for purposes of providing ongoing support. Legal representation is also quite important. So with that, I'll turn it over to Joanna.
Thank you so much. Um, when I'm representing a client, I like to think of myself not necessarily just as an attorney, but you're a strategic partner. And so what's important to remember in when you're looking to secure trademark protection, at least, it's that it's a legal process. And so while there are a lot of helpful resources on the USPTO, sometimes you'll see advertisements for do it yourself, or let us do something for you. But at the end of the day, it is a legal process. And I would say, just from a boots on the ground perspective, the foundation to securing your trademark protection is to have a solid search from the outset. And that's where legal representation can definitely be beneficial. Why is that? Because there's databases outside of the USPTO where attorneys can help to look. The World Intellectual Property Organization's Madrid Global Brand Database is one of them. That's WIPO Madrid. So that way, when you're looking at a search, you're looking not just, yes, trademarks in the US are for the US. However, you want to cast a nice wide net so that you're capturing registrations that could be outside the country, but also, out on the internet as well. And so, because there's you have the registered marks, but then you have something called common law trademarks. And so those are the ones that aren't registered, but that could potentially pose an issue when it comes time to apply. And so having an attorney with you to guide you is also very good in helping you get ahead of the curve to anticipate potential issues. And depending on what that search will yield, then you can develop a strategy for how to react to office actions should you decide to apply for a mark and then an office action issues because of something that your examiner found. And so it's good to get ahead. And that's the foundation to this whole process.
Thank you so much for saying that last part. And actually, this speaks to what both Stephen and Joanna just said, because I forgot. So my company name, I changed it this year to Forward Collective Group, but for years it was Dream Forward Consulting. The reason why Dream Forward Consulting was never trademarked is because there were a ton of other companies who had been using it. I think somebody even had something with Dream Forward trademark somewhere in a class or something like that. And so, with my attorney doing that due diligence first to do the search, she found that it was too many similar trademarks. And so she was like, you can try, but 9 times out of 10, it's going to end up being rejected. So she was like, we either need to trademark the logo itself, because I'm pretty sure that'll be unique, or some other element of the business that's related to it. Well, now the company name has changed. So that's actually not even something that's relevant. So I'm kind of glad I didn't do that because, again, don't use it anymore. But that just speaks to what Stephen and Joanna have both said about that due diligence. And that's a part of managing risk, because I wouldn't have known all of the places to check. And she always gives a very detailed report about any similarities, what classes they are, what they're doing, like very, very detailed research. And so, just a quick note for the people who are like, this is a lot of money, I don't want to pay this. That is the type of brilliance that you are paying for. Again, I'm not an attorney. I thought I was gonna be one watching Jack McCoy on Law and Order as a kid, but that dream did not materialize. And so as a result, I know what I know, not what I probably need to know to do this. And so having an attorney has been super helpful, because that would have been wasted money from the standpoint that it was probably going to get rejected, and I was able to instead focus on something else that was low risk, that I knew would be able to get through, that I also needed to protect. So this is where that planning comes from, because if you find that, like, let's say you want to apply for 5 copyrights, uh 3 trademarks, and a patent. Listen, unless you just rolling in dough, you might want to budget that out, right? And budget out the time needed to focus on that. So if it's something that's high risk in terms of potential for rejection, right? When you apply, and maybe it's low risk in terms of somebody being able to duplicate or poach that idea or manipulate it. Okay, maybe we'll put that on the back end and rethink how I want to protect that aspect of my business. Let me front load this first effort up, and you can sequence out your protections that way to create the layers that you need. So it is both an art and a science to this thing, which, like I said, I'm a smart lady, but I don't know that type of stuff. And so having an attorney has been incredibly helpful. All right, so second question. How can legal representation be useful after I successfully file and register? Because I think for some people, they think, okay, once it's done, thank you so much. I don't need you anymore. And especially when you are managing the timing related to certain things. I'm going to start with Stephen and then move to Joanna and finish up with Tomeka. Again, how can legal representation be helpful and useful after the success of a filing or registration?
Well, there are several different aspects of continuing representation, so to speak. Certainly, one is maintaining your rights. You have specific events that occur both with patents and trademarks that require activities that need to be filed with the USPTO in order to maintain your rights. So you want to be sure that you're on top of that. Your attorneys will docket those things and certainly provide you with notice. Enforcement. If somebody is using your intellectual property, you have the ability to be able to stop them potentially from doing that. And you need to have consultation clearly and know the law to be able to do that. And attorneys can be extremely helpful and beneficial there. Ongoing monetization also is another aspect. Licensing, going out and trying to assist you in developing marketing plans and other activities that can also be protected while you grow your business. Extremely important as well. Entrepreneurs, start things, they want to continue them and grow them, and that's what the attorneys can help with. Joanna, over to you.
Thank you. Okay, I was making sure I wasn't on mute. Um, Another important aspect, at least with regards to trademark protection, and I think for patents as well, and that is also if you're a business that's doing very well in the United States and you are looking to move abroad and you're wanting to work abroad, there's different treaties that can be invoked internationally so that you can preserve the priority date of your U.S. trademark registration or your U.S. patent when filing abroad. However, the clock does start ticking once you file in the US in order to then invoke that priority outside of the US. And so for patents, there's something called the Patent Cooperation Treaty, where you can file either through the World Intellectual Property Organization and then select the member countries where you are looking to obtain protection outside of the United States. And so with that one common application, it'll shoot out to the different patent offices. However, it is important to note that each country will then do its own independent examination. And so an attorney can be very helpful in that you can leverage our networks and our resource to help you find competent, solid local counsel that we trust and that we know are going to do a good job to help you then secure the patent rights that are the same patent rights that you worked so hard to achieve, to obtain in the U.S. to then also have protection outside of the U.S. So, for example, like in the European Union or in Japan, then you're able to do that. And with trademarks, then there's also the Madrid Protocol, where it's a similar process where you can file for protection through the World IP Organization and be able to keep that priority date, that date of protection from the United States in a different member country.
I definitely want to come back and like double click. Matter of fact, hold on, Tamika. I'm gonna get to you in 1 second. Cause she just dropped some gems. Now let's be clear. Y'all might be like, I know all of this about how to file. Okay, cool. But do you know about the World IP Organization? Do you know about the majority? No, like I've never heard of nothing that she's talking about right now. So this is what I'm saying, where people have areas of specialty that can be beneficial to your company in this era of bootstrapping. And let me tell you, I am a proud bootstrapper. I love understanding and knowing how to do all the pieces of my company. But, and Steven said a key word with this, when you are looking to scale, you cannot scale without specialization. Period. I don't care what anybody says. You could start something on your own and you do all the things. But to scale, there are people who their life's work is to know tons of stuff, just like it's your life's work. I don't know all there is to know about marketing, about accounting. I don't know all there is to know about any number of things that my business needs. I might know a little, I might know some surface knowledge to be able to find the right partner, but you are not in the professional associations. You are not connected to these organizations. You are not registered with them. You don't have a network of other attorneys. So, like Joanna said, look, you might need an attorney from a country in the European Union that specializes in knowing, hey, what is going on with Denmark? What is going on with France and what they are requiring for the I don't know those people. I know a lot of folks. I think they're all amazing, but I don't know attorneys in France, right? And so having legal allyship helps you to smoothly navigate these processes because you might have the opportunity to sign an 8-figure licensing deal with a company or with a partner in France, but you need to have this protection in place because you know for a fact that there is an emerging competitor. And so that could be the make or break point between you moving closer to an exit or moving closer to doubling your company's revenue or kind of languishing in smaller markets. So please be aware of these things. Thank you to Joanna for bringing that point up, because global expansion, I'm sure, is on everyone's mind and should be, but it takes a level of sophistication and, quite honestly, expertise that the average person just doesn't have by design, because that's not your body of work. All right, finally, Tomeka. Again, how can legal representation be useful after a successful filing?
Oh, well, that's a great question again, Kaylin. And I know that both Stephen and Joanna touched on many excellent points. And I'll just add on to that. Consider, again, your maintenance, those maintenance fees, right? Those are extremely important on both sides of the house, patents and trademarks. Also, in reference to those fees, think about it. You have to file them in a timely manner. So, for instance, if you're like, oh, I don't even remember when this was actually done before, it's really important, because if you have that legal representation, they can bring up reminders. Oh, it's time. The maintenance fees are required. And think about this. If you forget about your fees and you're like, oh my gosh, I've totally forgotten, my patent, for instance, is expired. I need to get it reinstated. How do I do that? So again, that legal representation would be, an excellent person or persons to have to help with that process. And also just consider the fact that you have renewals. Proper forms need to be filed. And again, the timing is everything. And if you even needed to update your entity status, if you're a small or micro entity, if things have changed or you want to change ownership, all of those things all fall under the umbrella of having that legal protection and continuing the life of your patent or trademark or any of your intellectual property.
Awesome. Thank you all so much. This has been such a good session. Every session that we have, I learned some new stuff too. And I'm like, I hope people are taking notes. This is really dope. But I want to make sure to leave just a little bit of time to talk about this final question, because again, we've walked through a ton of online resources, which are super helpful and is good for self-guided knowledge. But I think that it is also important to understand that there are real people who are reviewing these things in the USPTO. And so a part of the process is being able to engage with examiners. And so I just want to ask the three panelists just really quickly to wrap us up. How can we learn more and understand more about how to engage with examiners through the application process? Joanna, I'm going to start with you and then move to Tomeka, and Stephen, I'll have you close us out.
Um, in in my dealings with examiners, I have found most are quite helpful. The really the first Most of the time when you're the first encounter with an examiner is usually because an office action has issued. That's normally how it starts, right? It's in the at least in I don't work patents. I work trademarks, so I'll just speak to the trademark side of things. But what I have found is that um, yeah, the first encounter with the examiner, it's usually because there's an issue with the application. And then how what the dance with the examiner is going to look like a lot of the time is going to depend on the issue with the application. That being said, um, what I have found to be helpful, and this is and it's anytime you read your office action, and if you're not 100% sure what it is that the examiner is trying to say, pick up the phone. Your office action is going to have the contact information for the examiner. There's a phone number there. You can pick up the phone and you can give them a call and just say, hey, I'm reading through this. I'm not quite sure what you're getting at with respect to this, and let them walk you through it. Sometimes if the issue is that you didn't quite identify your goods and services in the right way, sometimes you'll see in office actions that the examiner will propose corrections for you. And so if the corrections are accurate for your business and for your plans, if they make sense, then it may be worth considering adopting those corrections. Or if they're not entirely there, like if they get you 3/4 of the way there, but they're not completely accurate, again, you can pick up the phone and you can have something to where, and this is where having an attorney is great, because when it's an attorney, the examiner is also, they're an attorney too. They're an examining attorney. And so you speak the same language, and you can get on the phone and say, okay, this correction is good. However, we need this adjustments, and you can actually come up with a mutually agreed description that then you can write it up, you enter it, and then from there, your application should be able to glide, at least with respect to that. So they're human beings, and most of them are lovely. So just a lot of the time, it's just a matter of picking up the phone.
Agreed. I'll just add to that. You can definitely engage with the examiners at the USPTO in a variety of ways, directly with the examiner if there are any issues. And the USPTO also encourages the examiners to also reach out to our stakeholders. So that's really important part of the process, or the patent examination process. Also, we have the Inventors Assistance Center. That center is staffed with former supervisory patent examiners and experienced primary examiners, and they are able to answer general questions concerning your patent exam, your application, and examination policies and procedures. Those are just a few. And if there are any issues that arise over time, we also have the Patents Ombudsman Program. So there are many ways to engage with examiners at the USPTO.
So I'll just let everyone know that getting a hold of the examiner, scheduling interviews on the patent side, engaging with an interview with a trademark attorney when you don't have a clear understanding of what the office action says, as Joanna suggested, all of those are extremely beneficial for many reasons. One, it'll allow, hopefully, to get the protection that you're entitled to, and the broadest possible protection. It will also provide you with the opportunity to be able to engage with the examiner for purposes of streamlining the activity and getting things to move forward quickly in the patent office. The longer, the writing process sometimes is a very slow and arduous process, but it works. Picking up the phone, speaking with an examiner, scheduling an interview on the patent side, and particularly in design patent matters. That's another aspect we haven't spoken about, but they're very important. And there are very nuanced activities that take place with design patent applications, including the drawings. And so when you need to revise those types of activities through the patent process, extremely important. And then last but not least, certainly the USPTO itself has a tremendous amount of materials that will allow you to be able to understand what an examiner is doing in the training materials that are available to both the public as well as the attorneys. They get an understanding of how the examiners work, what their duties and goals are, and it's very helpful to be able to understand that throughout the process. Hopefully that's helpful.
Is very helpful. All of the information that you all have provided has been so incredibly helpful. Thank you so much again. I hope you all are taking notes, thinking through. I hope you have the USPTO's website open to be able to search through the resources. The key takeaway here that I want to just drive home again as we wrap for the day is that number one, there are a ton of free resources available on the USPTO.gov USPTO.gov website to learn about all of the types, plus the resource centers, learning resources, how to find an attorney. But second, this is from me to you. This is Kaylin Romaine speaking. It is incredibly important to secure legal allyship and partnership for the process. Joanna and Stephen have done an incredible job of explaining all of their expertise, some of the nuances that they just listed, design patents, international protections. Those are things that honestly the average inventor, creator, or founder is not going to know about because you know your business, not all business. And so having the right partner makes all the difference in the world. Thank you so much to our guests for today. I'm so grateful for this collaboration with the USPTO. Real quick, I don't know if y'all want to hop on camera, but I know Kim and Elizabeth are here. They were also here just to represent as well. So grateful for their presence. And thank you so much to Tomeka, to Joanna, and to Stephen for your expertise that you shared today. So grateful for you all. Of course, last but finally not least, happy holidays to everyone. Happy New Year. And I hope that one of the first steps that you take for the new year is to secure protections for all of the brilliance that you are creating and sharing with the world. I'm going to be sure to leave the contact information for Stephen and Joanna in the chats on LinkedIn and on YouTube so that you can access this information again to access them, I'm sorry, and secure time with them. And then I'm also going to leave the link to access the USPTO's resources as well. Thank you all so much. Happy holidays and take care.
Happy holidays.
Happy
Thanks,
holidays.
Thank
everyone.
you. Happy holidays. Thank you for the opportunity.
Thanks a
Thanks
lot.
for having
Everyone.
us.
Bye.
Take care. Bye.
Thank you all so much. Appreciate y'all.